हेलो फ्रेंड्स, वेलकम बैक टू माय चैनल। आज हम लोग डिस्कस करने वाले हैं नेशनल ह्यूमन राइट्स कमीशन। ठीक है। एस्टेब्लिशमेंट ऑफ द कमीशन। द नेशनल ह्यूमन राइट्स कमीशन इज अ स्टेटरी, नॉट अ कॉन्स्टिट्यूशनल बॉडी. It was established in 1993 under a legislation enacted by the Parliament, namely the Protection of Human Rights Act 1993. This act was amended in 2006. This is not a constitutional body. This is a statutory body. The Commission is watchdog of human rights in the country, that is, the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international conventions and enforceable by the court in India. The specific objectives of the establishment of Commission. क्या उद्देश्य था इसके पीछे, इसको एस्टेब्लिश करने के पीछे था? To strengthen the institutional arrangement through which human rights issue could be addressed in their entirely in more focused manner, to look into allegations of excess independently of the government in a manner that would underline the government's commitment to protect human rights, to complement and strengthen the efforts that have already been made in this direction. Let's talk about the composition of this commission. The Commission is a multi-member body consisting of chairman and 4 members. The chairman should be a retired Chief Justice of India, and member should be serving or retired judge of the Supreme Court, a serving or retired Chief Justice of High Court, and 2 persons having knowledge or practical experience with respect to human rights. In addition to these full-time members, the Commission also has 4 ex officio members: the Chairman of National Commission for Minorities, the National Commission for SCs, National Commission for STs, and National Commission for Women. The Chairman and member are appointed by President on the recommendation of 6-member committee consisting of Prime Minister as its head, the Speaker of Lok Sabha, the Deputy Chairman of Rajya Sabha, leaders of the opposition in both houses of the Parliament, and the Central Home Minister. Further, a sitting judge of Supreme Court or a sitting Chief Justice of High Court can be appointed only after consultation with the Chief Justice of India. The chairman and members hold office for a term of 5 years until they attain the age of 70 years, whichever is earlier. After their tenure, the chairman and member are not eligible for further employment under the central or state government. The president can remove the chairman or any member from office under the following circumstances: if he is adjudged or insolvent, if he engaged during his term of office in any paid employment, if he is unfit, continue in office by reason of the infirmity of mind. In addition to these, President can also remove the chairman or any member on the ground of proved misbehavior or incapacity. However, in these cases, the President has to refer the matter to the Supreme Court for an inquiry. If the Supreme Court, after the inquiry, uphold the cause of removal advises so, then the President can remove the chairman or a member. The salaries and allowances and other conditions of service of the chairman or a member are determined by the central government, but they cannot be varied to his disadvantage after his appointment. All the above provisions are aimed at securing autonomy, independence, and impartiality in the functioning of Commission. Function of the Commission. The function of the Commission are to inquiry into any violation of human rights or negligence in the prevention of such violation by public servant, either suo motu or on a petition presented to it or on an order of a court, to intervene in any proceedings involving allegation of violation of human rights pending before court, to visit jail and detention places to study the living condition of inmates and make recommendation thereon. to review the constitutional and other legal safeguards for protection of human rights and recommend measures for their effective implementation, to review the factors including act of terrorism that inhibit the enjoyment of human rights, to study treaties and other international instruments on human rights and make recommendations for their effective implementation, to undertake and promote research in the field of human rights, to spread human rights literacy among the people and promote awareness of the safeguard, to encourage the effort of non-governmental organizations NGOs working in field of human rights. Working of the commission. The commission's headquarters is at Delhi and can also establish office at other places in India. It is vested with the power to regulate its own procedure. It has all the power of civil court and its proceedings have a judicial character. It may call for information or report from central and state government or any other authority subordinate thereon. The commission has its own nucleus of investigation staff for investigation into complaint of human rights violations. Besides, it is empowered to utilize the service of any officer or investigation agency of a central government or any state government for a purpose. The Commission is not empowered to inquiry into any matter after the expiry of 1 year from the date on which act constitutional violation of human rights. The Commission may take any of the following steps during or upon the completion of an inquiry. It may recommend to the concerned government or authority to make payment of compensation or damage to the victims. It may recommend to the concerned government or authority the initiation of proceedings for prosecution or any other action against the guilty public servant. It may recommend to the concerned government or authority for grant of immediate interim relief to the victims. It may approach the Supreme Court or High Court concerned for necessary directions. Role. Let's talk about the role of the Commission. From the above, it is clear that the function of the Commission are mainly recommendatory in nature. It has no power to punish the violators of human rights, nor to award any relief, including monetary relief, to the victims. Notably, its recommendations are not binding on the concerned government or authority, but it should be informed about the action taken on recommendation within 1 month. In this context, a former member of Commission observed, the government cannot wash away the recommendation made by the Commission. The Commission's role may be recommendatory, advisory, yet the government considered the cases forwarded by it. It is therefore improper to say that Commission is powerless. It enjoys great material authority and no government can ignore its recommendation. Moreover, the Commission has limited role, power and jurisdiction with respect to the violation of human rights by the member of armed forces. In this sphere, the Commission may seek a report from central government and makes its recommendation. The central government should inform the Commission of the action taken on the recommendation with 3 months. The Commission submits its annual or special report to the central government and to the state government concerned. These reports are laid before the respective legislature along with a memorandum of action taken on the recommendations of the Commission and the reason for non-acceptance of any of such recommendation. Let's talk about the performance of the Commission. The various human rights issues taken up by the Commission: abolition of bonded labor, functioning of mental hospital, Ranchi, Agra and Gwalior, functioning of government protective home, Women Agra issue concerning right to food, review of child marriage restraint act 1929, protocols to the convention of rights of child, preventing employment of children, child labor, media or sexual violence against children, trafficking in women and children, manual for judiciary, anemia, disease. This is the all issues which are dealt by the Human Rights Commission. Okay. Human Rights Amendment Act 2006. Parliament has passed the Protection of Human Rights Amendment Act 2006. The main amendment carried out in the protection of human rights in 1993, reducing the number of members of State Human Rights Commission from 5 to 3, changing the eligibility condition for appointment of member of State Human Rights Commission, strengthening the investigate machinery available with Human Rights Commission, empowering the Commission to recommend award for compensation, etc., empowering the National Human Rights Commission to undertake visit to jails without information to the state government, strengthening the procedure for recording of evidence of witnesses. Okay, clarify that the absence of any member in selection committee for selection of chairperson, member of National Human Rights Commission and State Human Rights Commission will not vitiate the decision taken by the commission. Okay? These are all about the National Human Rights Commission. Tomorrow we will talk about the State Human Rights Commission. Till then, thank you, and let's continue watching my channel for new updates regarding Indian polity. Okay, thank you.